Thank you guys so much.
Well, you haven't run anybody out of the room yet.
No. Normally I would expect a certain amount of attrition after that level of bloviating. But, okay. So if there are no additional questions with respect to the gifts restrictions, and of course, keeping in mind your own code of conduct, which is replete with granular additional gifts requirements and nuances that I highly recommend. I also saw that you have a hotline, a compliance hotline that you can avail yourself of, and a person who functions as the chief compliance officer that you can ask queries about, in addition to that of the Commission on Ethics. The last slide in here, for those of you that are shy with your questions, is going to be my own contact information. And I welcome any questions that you might have. If after this lecture you think, oh, that actually raised some queries that I have, please feel free to give us a call at any time. You can even ask for the ethics attorney, and at any time, even if I'm out of the office, you can get, within minutes, a response. You can talk to a full-time ethics commission attorney. Okay, so we're in the home stretch of the ethics lecture now, and so we've refreshed ourselves with a break, because now we're going into a dense topic, and that topic is conflicts of interest. It is imperative to the successful functioning of the government that conflicts of interest be mitigated to the extent possible. However, we are actively engaged in, as public servants, as nodes of the government, of enticing, encouraging, and facilitating people to serve on boards like these commissioners have. Thank you again. And in respective public capacities, I just met an individual who himself has storied levels of public service too, in fact. And so I want to talk to you about the nuances of the conflicts of interest statutes, okay? Why do conflicts of interest matter? People think it's, a Herculean task to even understand what a conflict of interest is, but a conflict of interest within the Code of Ethics simply means a situation in which regard for your private interests tends to lead to a disregard of your public duties or public interests. And so to the extent that this can be mitigated, it is imperative. There are two types of conflicts of interest in addition to voting conflicts, okay? So voting conflicts is over here, and then over here are two different types of conflicts of interest. We refer to both of them as status conflicts. That means if the components of these two things that I'm going to talk to you about exist, then you could be faced with a prohibited conflict of interest, one that would need to be mitigated. The conflicts of interest, big picture, reason why this matters is because of this. Because the protection of your impartiality as a public servant can be impugned, or there can be an appearance of besmirchment when a conflict of interest is determined to exist. Okay, so let's talk about the two types. I'm going to break these up. There are two types of conflicts of interest. I'm going to start with the second one first because we have the most complaints and the most questions about it. It involves conflicting employment or contractual relationships, and it has two separately enforceable prohibited parts. This is implicated when you have a public servant position, like you're a public officer, or you're an attorney for the Commission on Ethics, and you have a moonlighting scenario where you also have a private business or private interest contemporaneously with your public office or your public employment. Okay? Public, private. And it has two prohibitions that you need to be cognizant of when you're engaged in those types of activities. The first provision of the conflicting employment and contractual relationship conflict of interest provides that a public officer or a public employee is prohibited from working for or having a contractual relationship with any business or agency that does business with their own agency or which is regulated by their agency. Okay? And agency, for the purposes of this board, is your board and the special district itself, as you can imagine. But it has been defined in our advisory opinions to, this is our metric, the lowest departmental unit upon which your authority may be felt. Now, the more authority your board has, the more the penumbra of your authority wafts further, I guess, into the special district. The second part, and I'm going to give you some examples once I go over both of these, provides that you cannot have, even when you don't have a conflict of interest in fact, you can still have a conflict of interest if you have an employment or contractual relationship that creates a continuing or frequently reoccurring impediment to the full and faithful discharge of your public duties. Okay, so an example of part one. All right, say you sit on a pension board that makes determinations with respect to pension investments. In your private capacity, you have an actuarial firm that provides actuarial services to accountants and insurance, blah, blah, blah. Your board puts out a request for proposals or considers the putting out of a request for proposals for a firm to provide your board with actuarial services. And you think, I know exactly who we should pick. Me. I would love to approve my own contract for me to be employed by me. If you're employing you while being employed by the public, there's probably a conflict of interest involved. Okay? An example of the second part involved an advisory opinion which I had the privilege of analyzing, which involved, okay, an individual, a public servant, serves on a board that meets very infrequently, only twice a year, and their sole job is to make determinations about the amount of public funds provided to private nonprofits that serve their community. This individual in his private capacity was a partner in a law firm who was suing two of the nonprofits applicants for his board that were coming up before his board for funding. He referred to them as dirtbags. He had real strong opinions about them, perhaps well-founded, but obviously it created his private interests, the lawsuits, created an impediment to the impartial functioning of his public duty. Okay? So, the 4th District Court of Appeals, in analyses of this ilk, has said, we have to, the Commission on Ethics, weigh the person's public function and public duty with those requirements of their private interest. And where they overlap, that's where you need to have concerns. Because that's our primary area of scrutiny. Okay? This is not to say that you as a public servant are prohibited from having private employment. That would stymie the functioning of government and the functioning of good governance. It is to say, though, that impartiality matters, and it is legally required. Okay. The other type of conflict of interest comes from doing business with your own agency. As you can imagine, doing business with yourself, doing business in your private capacity with yourself in your public capacity can be problematic, and that problem has a name, and that name is conflict of interest. This provision also has two parts. The first part prohibits a public officer or public employee acting as a purchasing agent or a public officer acting in their official capacity, meaning as a member of this collegial body, from buying or renting any land, goods, realty, or services from a company which they, their spouse, or their child are an officer, partner, director, or proprietor. They are also prohibited under this first provision from buying or renting any land, goods, realty, or services from a company which they, their spouse, or their child, or any combination thereof, have a material interest. And that is defined to be more than 5%. Okay? So, I'll give you some examples of these in a moment. But before that, let's go on to part 2. There's a separately enforceable clause that's the second part of this doing business with your own agency prohibition. It prohibits agency officials and employees are also prohibited from acting in their private capacity to rent, sell realty goods or services to their own agency or a political subdivision of that agency which they serve. Okay? An example of types of conflicts of interest arising under doing business with your own agency. You are a head partner in a law firm and a member of a collegial body, that's a board. Your board needs a law firm to provide it with counsel. You immediately think, I know exactly the firm that would be the best firm to provide these services to my board, myself. And that provides a conflict of interest. And that conflict of interest is created by the contractual relationship you form essentially with yourself in your public capacity. So, as you can imagine, members of the public, when they see these types of arrangements, think inside baseball. Because, in truth, it is. Often, these types of conflicts arise where there's no process at all. I pick myself because I know myself so well. And I know how wonderful my own law firm is because I'm in it and I love it. And it may be true that you are a superlative member of your firm, practicer of the law, public servant, and partner. But all those things at the same time is a recipe for a conflict of interest. Now, there are a host of exceptions, okay, that exist with regard to these two provisions to allow for the retention and collection of individuals who have knowledge and experience and are adept with regard to their qualifications to enable them to serve, okay? First and foremost, I want you to know about grandfathering. Grandfathering itself is written into the statutory language of doing business with your own agency and has been read into the first conflict of interest provision. It attaches automatically and it creates an exception for business people who have contracts that pre-exist them becoming public servants. So if you had a contract with your agency that existed before you even were appointed to the board, or were elected to serve, or were, in a public capacity at all, you're obviously not subject to the code of ethics when you're not a public servant because a public office is a public trust. Once you become a public servant, those agreements and contracts are grandfathered. And that grandfathering exists until the contract is either renegotiated or terminated. If you, however, during your public service, seek to change substantively the terms of that contract, it vitiates the grandfathering. That's a new contract, and it could give rise to a prohibited conflict of interest.
What about the Evergreen Provision?
The Evergreen Provision?
Over here.
Oh, Evergreen Provision?
So you have an Evergreen Provision in an agreement. The agreement continues, I guess, according to those terms, but in perpetuity in theory. But the very nature of not raising any type of renegotiation or RFP or what have you, how is that?
Excellent question.
Which I want to be clear, I don't have a conflict with. Just curious.
Asking for a friend.
No, actually.
I totally get it.
It's actually an acquaintance.
Indeed. That is an excellent question, one which the Commission on Ethics has actually addressed. And when the grandfathering attaches, we've said it will continue to attach if there is an evergreen provision in the contract that essentially renews it based on its same terms with no changes substantively to the contractual provisions. And that can include like a whole host of things, but so long as it is a true blue evergreen provision that renews it based on the original terms for the original duration and the original amounts.
But couldn't there be a conflict by not seeking another provider for that service or another office place to rent or whatever?
Those can be characterized, it's not a conflict of interest, but it can be a deficit theoretically, like as terms of, you know, you might not be able to get it at as good as that original price. But what we're talking about is conflicts of interest, the liability for which is personal to the public officer.
Okay, thank you.
I have a question also.
Please.
What if it were a self-renewing contract, an evergreen contract, but it had a cost of living provision or an automatic increase in the financial terms of the agreement?
We have said that so long as the renewal is for the same specified period and the provisions of the contract under the renewal are the same as the provisions of what would tacitly be the original contract, that those nuances of that contract would not vitiate the attachment of the grandfathering exception. And we've said this repeatedly since the 80s, in fact. CEO 85-40 was the first time, but in a myriad of other opinions, including one issued in 2009, CEO 09-1, we have adhered to this. It's a mechanical, we're looking to see to make sure that the renewal is in fact a true renewal and not a fiction.
Thank you.
Okay. Any questions, other questions about conflicts of interest? Excellent. Okay, I have to do this over and over again. I don't know why, but this little guy right here just gives me so much joy. There we go. The misuse of public office. The misuse of public office, as you recall from many moons ago when we first embarked on this ethical journey together, is the number one most investigated node of the Code of Ethics. It, as one could characterize, generates the most liability. But that's because of the import of its provisions. The misuse of public office provisions, section 112.313, subsection 6, prohibits any public officer or any public employee or any candidate for public office from using or attempting to use their public position or any public resources within their public trust to secure a special private benefit or privilege for yourself or any other person connected with you in a private capacity. Okay? So, as you can imagine, this generates a lot of complaints. Here's what it's not. It's not, this government official is not listening to me. They have not done what I want them to do. I told them what I wanted, and they didn't do it. It is not a perceived waste in government or a mismanagement on a theoretical policy level of government resources. It is not being rude or being a human being or having a bad day. It requires, for a misuse of public office to be present, an intentional conduct of some ilk to use your official position, the authority of your position, your title in your official position, or any public resource to gain a private benefit for yourself or anyone else, a girlfriend, a boyfriend, a paramour, an acquaintance, any of these individuals, if you are using or misusing your official position. So some examples of conduct which has been investigated and liabilities ensued with respect to the misuse of public position include conduct which might generally be referred to as sexual harassment, especially where the sexual harassment is, I'm in a position of authority that's public in nature and I'm sexually harassing my staff. Because we all know what the benefit is there, but the misuse is clearly present there as well. Threats by city commissioners to terminate an employee over a private dispute, such as, I hate my neighbor. They are publicly employed. I would like to have them fired because I hate them. That's obviously a misuse of public office. Threats by city commissioners, mayors, to terminate police or diminish police budgets or diminish the budget of particular particular public officers like police department members and sheriffs for not doing away with tickets, for not doing away with arrests and things like that. That's obviously a misuse of public office. So should, after this incredibly life-affirming lecture, you go out and have a bunch of margaritas and you get pulled over, let's not remind people about the public office that we hold. Let's just keep that to ourselves. An ancillary charge, often with a misuse of public office, is a misuse of public information. And this applies to both current and former public officers and public employees. It prohibits these individuals from using public information not available to members of the general public and gained by reason of their public position for their personal gain or personal benefit, or for the benefit of those individuals connected with them in a private capacity. Okay, so this one has kind of a painful, when we see this often, it involves ex-spouses and criminal databases and public servants who have unique access to those criminal databases searching the paramours of their new ex-spouses. And that is not a useful undertaking. I do not encourage anyone to do it. Surely in your capacity in the health profession, there's an enormous amount of databases that you have access to that are protected from general public analysis. Do not use them to search your girlfriends or boyfriends or your ex-spouses. Use them only for the purpose for which they are intended, which is to serve the public that we serve. Okay, so I saved this one for the end because we're all probably tired, and if you don't want to ask any questions about this one, I'm perfectly fine with that. Voting conflicts of interest, section 112.3143. As you know, you are uniquely required to adhere not only to section 112.3143 subsection 3, which applies to public officers, all public officers, but you also must comply with 4, which applies to appointed public officers. And compliance with both is not labyrinthian, but it is a little bit more challenging. You utilize the Form 8B because you are local public officers. The voting conflict statute only applies to collegial bodies, but it has many components. A local elected or appointed public officer may be faced with a voting conflict that would require certain things to transpire if they are faced with a measure before their board in which, for a vote, if it could inure to the public officers, meaning your special private gain or loss, to the special private gain or loss of a relative, a business associate, or a principal by whom you are retained. And a principal by whom you are retained is defined within the statute to include a whole host of individuals, including a parent organization or subsidiary or sibling of a corporate principal by whom you are retained, your employer, a client of your firm in your private capacity, a a corporation for which you serve as a compensated director or officer. All of those could be principles. Okay, so just to be clear, you may be faced with a voting conflict if your measure before your board could inure to your special private gain or loss, to that of a relative, a business associate, or a principal. However, not every measure that could theoretically implicate a special private gain or loss is an underpinning of a prohibited conflict of interest such that abstention is required. For this reason, you gotta ask yourself a few questions. And the Commission on Ethics has developed a series of metrics which, beginning in 2012, have been codified into the statute themselves, into the definition of special private gain or loss. I believe it's in section 112.31431D. And it provides in this section that special private gain or loss is not everything. Because think of it. If you were a city commissioner serving on that collegial body and you were a homeowner, literally everything. Say you were a former firefighter and you have a pension that's provided by your city. Now every budget puts you in handcuffs and you think, oh, I shouldn't vote on anything ever. No, that's why these metrics exist. And so we ask individuals serving on collegial bodies, when faced with a potential special private gain or loss, to analyze, is it special? And first and foremost, is it a gain or loss? Meaning, is it an economic benefit or harm to these classes of individuals? Myself, my business associate, my clients, my employer, i.e. my principal, my relatives. And even then, it has to have one of these metrics present in order to tip it over. Now, obviously, in recent vintage, the provisions of the Meeting Governments Law 286.01, which previously was cited to say, people on serving in collegial bodies to say, when I'm physically present, I have to vote. I must vote. But some language was added in 2013 that said, unless you have to vote, unless you are faced with a voting conflict or the appearance of a voting conflict. They added the word appearance of 3 times in that statute to allow for some leeway when you think you might be faced with one. And if you think that you might be faced with one, then by all means, abstain. And I'm going to talk to you about the things that are required as appointed officers of collegial bodies. But in looking at a measure that could inure to your special private gain or loss or to that of the other individuals, I ask you to look first and foremost at the size of the class. Okay? If there is an enormous array, an enormous numerical amount of people affected by the size of the class, and your brother is one of 10,000 people, then the size of the class is such that that probably is not going to manifest a special private gain or loss to that relative. Is there a unique impact? Is the vote itself remote or speculative? Is there like 5 other votes that have to take place in order for that benefit to make itself apparent? Is it preliminary or procedural? Okay, I'm going to give you an example. All right. So in CEO 00-13, we were faced with a retired firefighter who was elected to serve on the city commission. He was faced with voting changes on the city's collective bargaining agreement that ultimately affected the retirement system, a system of which he had a vested interest as a person who collected a pension, as a former firefighter. And he asked, am I faced with a voting conflict? We're going to have to vote on this. We're literally voting on it for the next year in a series of votes that are incremental in nature. And in that opinion, 00-13, we said no. Because in that instance, under those metrics that I just discussed, the size of the class, he was one of a bunch. There was no unique impact to him for the series of votes. Many of the votes were preliminary at the stage that he asked the question. And any inuring of any benefit or detriment was very remote and speculative. So under all of the metrics, his special private gain was not special. It was not unique to him, and therefore he was not required to refrain from voting, okay? But let's change those facts a little bit and say, all right, let's say he's in a unique class of firefighter that served for a specific duration, and they want to honor those people by giving them special benefits in these votes, okay? So they've carved out a special smaller group. Now we have a smaller class, of which he's one of just a few, and there's some unique impact. Now he's like, whoa, well maybe I changed my facts. I might be faced with voting conflict. What does he do? Okay, so I want to, because you are required to comply with subsection 3 and subsection 4 as appointed local government officers serving on a collegial body, you should be very careful. Read your Form 8B. It's got 2 parts, local government officers, hello, and it's got appointed. You want to make sure you're following that with particularity, and I'm sure Lynn helps you with exactitude. But at the very least, you must publicly disclose the conflict orally prior to the vote, abstain from voting, and file a memorandum of voting conflict within 15 days. Okay? And there is some additional granular requirements in the event that you're faced with a conflict, you intend to abstain, but you would like to converse about it. Okay? You are not prohibited from sharing your wealth of knowledge. And I know that the people who serve on this board, having known some of them, are replete with knowledge and experience. And you might have something very valuable to add to the dialogue. You're not prohibited from doing it, but you have to do some of these things first, especially the disclosure. Prior to your location, please disclose. And I'm sure Lynn will help you with that, but I wanted to let you know your hands are not completely tied. Some people feel that they have to get up and literally leave the building. That's not what we're talking, that's not required by the law. Okay, so, and I asked this, I would like to ask this question from beneath this dais, but are there any questions about voting conflicts? Excellent, that's excellent. All right, thank you everybody. This is my contact information. I really appreciate your attention today. You've been an excellent audience. If you have any additional questions for me, I'm always available via email, and you can give me a call at any time and ask for me directly.
Thank you very much for taking the time to
Thank you.
come all the way from Tallahassee.
Absolutely, it's my pleasure.
If I could get a motion to adjourn, second? Hello?
Second? I thought you were saying second.
Wow.